Hey everyone, very good morning, good afternoon. Back to the channel. Bacho. Welcome back to CA classes. Yeah, we are completely dedicated to Hi Priyanka. The CA Foundation, the last part ಇದೆ ಇದು ಇಂಡಿಯನ್ ಕಾಂಟ್ರಾಕ್ಟ್ ಆಕ್ಟ್ ಇವತ್ತು ಡೆಫಿನೆಟ್ಲಿ ನೆಕ್ಸ್ಟ್ 90 ಮಿನಿಟ್ಸ್ ಅಲ್ಲಿ ಆದಷ್ಟು ಎಲ್ಲ ಕ್ವಶನ್ಸ್ ಸಾಲ್ವ್ ಮಾಡಿ ನಾವು ಮುಂದೆ ಹೋಗಬಹುದು. ಫಸ್ಟ್ ಟೆಲ್ ಮಿ ಮೈ ವಾಯ್ಸ್ ಇಸ್ ಕ್ಲಿಯರ್. ಎಲ್ಲರಿಗೆ ನನ್ನ ಧ್ವನಿ ಕೇಳ್ತಾ ಇದೆ ಎಲ್ಲರಿಗೆ? ಬೇಗ ಬೇಗ ಹೇಳ್ರಿಪ್ಪ. ಎಸ್ ಸೇ ಎಸ್ ಸರ್ ಅಂತ. ರೈಟ್, that we can start the class now. Priyanka, hedamma. ಧ್ವನಿ ಕೇಳಾದೆ ನಂದು? Can you hear me, ಬಚ್ಚಾ? ಹೇಳಮ್ಮ. ಕೇಳ್ತಾ ಇದೆ? Tell me. Hello, is my voice is clear? Looks like yes. ಲೈಕ್ ಮಾಡ್ರಿ, those who are watching on the YouTube. ಸಬ್ಸ್ಕ್ರೈಬ್ ಮಾಡ್ರಿ ಚಾನಲ್ಗೆ ಹೊಸದಾಗಿದ್ರೆ. ಮತ್ತೆ ಈ ಕ್ಲಾಸಸ್ ಎಲ್ಲ ಸಿಗ್ಬೇಕಪ್ಪ ಅಂದ್ರೆ ಗೈಸ್ ಡೆಫಿನೆಟ್ಲಿ ನೋಡಿ. Every day we are taking the classes. Contract Act I want to finish today, right? I've done so many parts, so many. ಬಚ್ಚೋ ಎಲ್ಲಿಗೆ ಬಂದಿದ್ವಿ ಅಂದ್ರೆ ದಿಸ್ ಇಸ್ ಗೋನ್ ಟು ಬಿ ಲೈಕ್ ಕಂಟಿನ್ಯೂ ಆಗ್ತಾ ಇದೆ, right? So here we are. Please read that, bacho. Let's start and let's finish chapter today. Okay, read the question, Priyanka. Odamma. Okay, let's start. Okay. Chalo. Nodi. Point out with the reason whether the following agreements are valid or void. Agreements indavalla, ಇದು ವ್ಯಾಲಿಡ್ ವೈಡ್ ಕೇಳತ್ತಾರ ಅವರು. ಓಕೆ, ಸೊ ವೈಡ್ ಆಗುತ್ತೋ ವ್ಯಾಲಿಡ್ ಆಗುತ್ತೆ, that we'll discuss now. And let's start now. ಏನಪ್ಪಾ ಅಂದ್ರೆ ಫಸ್ಟ್ ಕೇಳಲೆ, Kamla promised Ramesh to lend 5 lakh in her leave consideration that Ramesh get a Kamla's marriage dissolved. ಇದಾಗಿದ್ದು ಲಾಸ್ಟ್ ಕ್ಲಾಸ್ ಅಲ್ಲಿ. We have done this also. ಇದು ಆಗಿತ್ತು. This is also done. From here we need to start now. Okay? From here we need to start. What will be the right of the promiser? What will be right with the promiser in the following cases? Explain with the reason. What are the promiser? Promiser. Who is the promiser here? X is the promise. X promised to bring back Mr. Y's life again. What they want? ಏನ್ ಕೇಳಿದಾರೆ? ಎಕ್ಸ್ ಪ್ರಾಮಿಸ್ ಮಾಡ್ತದಾನೆ ಏನಂತ, ನೀನು ಸತ್ತೋಗಿದನಲ್ಲ ವಾಪಸ್ ತರ್ತೀನಂತ. ಅದು ಪಾಸಿಬಲ್ ಇದೆಯಾ? ಈಸ್ ದ್ಯಾಟ್ ಪಾಸಿಬಲ್ ಬಚ್ಚೋ? ಈಸ್ ದ್ಯಾಟ್ ಪಾಸಿಬಲ್? ಲುಕ್, so the contract is completely ಏನಾಗುತ್ತದು void ಆಗುತ್ತೆ, because it is initially impossible. In the first stage itself it is impossible. Impossible of what? Impossible to perform, because ಯಾರು ಸತ್ತೋಗಿರ್ತಾನಲ್ಲ, if somebody died means we cannot. When known to both the party, ಇಬ್ರು ಪಾರ್ಟಿ ಗೊತ್ತಿದೆ, parties, the contract is impossible to perform. The contract is discharged. Contract is discharged. ಗೊತ್ತಾಗಿದೆ? Understood. So first is what we have 5 marks questions. Next, A agrees to sell 50 kgs of apple to B. A agrees to sell, A promises to sell 50 kgs of apple to B. The loaded truck left delivery on 15th March, but due to riots right between in between reach on 19th March. But so what happens here? They promise to deliver the goods on 15th. Because of some riots and all, like they are not able to deliver it. So what is the case? time is a very essence of this contract here, because time is what? 15th March is the time they given. Correct? By this time, apples reached B. So they were already rotten, right? Because perishable goods it is. Goods in the agreement is perishable goods. The contract is discharged due to distinction of subject matter of the contract. Understood? Understood, bacho? Understood? Nodi, ille enaಗ್ತವೆ. A agrees to sell 50 kgs of apple. The loaded truck left the delivery for 15th, but it reached on 19th. So possibility is that it has been discharged due to time sense. Essence of this contract is time here. Correct? Because of the time, as the apple reached late and it may be rotten, kharab ho jayenge, cut hogirbaudu. Adake the contract is discharged due to destruction of subject matter. All right, bacho? All right. Next question. Next question. What is next question? An artist promised to paint the fixed date on the fixed date for a fixed amount of remuneration, but met with an accident and lost his both the hands. Impossible to perform. Performance is not possible here. Correct, bacho? Such contract of personal in nature, and hence contract cannot be performed. Remember, if any contract which required special skills ಏನಿರಬೇಕಾದ್ರೆ ಅಂತ ಕಾಂಟ್ರಾಕ್ಟ್ ಪರ್ಫಾರ್ಮ್ ಮಾಡೋದು ಇಂಪಾಸಿಬಲ್ ಆಗುತ್ತೆ, ಬಿಕಾಸ್ ಅದೇ ಪರ್ಸನ್ ಪರ್ಫಾರ್ಮ್ ಮಾಡಬೇಕಾಗುತ್ತೆ. ದಟ್ ಪರ್ಸನ್ ಓನ್ಲಿ ಹ್ಯಾಸ್ ಟು, ದ ಪರ್ಸನ್ ಹೂ ಹ್ಯಾಸ್ ಪ್ರಾಮಿಸಿ or promiser, right? They only has to perform this. Bacho, what happens that such contract personal in nature, right, and hence cannot be performed due to occurrence of event resulting in impossible to perform. Here the occurrence of event is he has lost his both the hand. Correct? So that is why it is impossible to perform from the promiser. Understood? Understood, bacho? Next question is, Abhishek entered into a contract of import of toys from China, but due to disturbance in the relation with the country, the import from China is banned. Bacho, enemy alien country antaralla, enemy alien country dalli enagutte, the import is impossible to perform. So bacho, what we can say is that such contract is discharged without the perform, because subsequent illegality nature in the contract of the illegality. If you do any kind of contract with them and that is enemy country, alien enemy country, it is illegal contract agutte. Without it is impossible to perform. Got it? Arth agideya? Understood, bacho? Understood? Can you go for the next? Idagidella idu. This is done. Okay. ಅರ್ಥ ಆಗಿದೆನಾ ಪ್ರಿಯಾಂಕಾ? ಬೇಗ ಹೇಳ್ರಿ. Tell me. Okay, here we have one more case study here. ಕೇಳ್ರಿ. A, B, C, D, 4 parties in a firm, okay, jointly promised to pay. They all together said they'll be paying 6 lakhs to F. B and C have become insolvent here. B and C become insolvent here. B was unable to pay any amount and C could pay only 50,000. A is compelled to pay the whole amount. To F. Decide the extent to which A can recover the amount from D. Because, bacho, here B and C are insolvent and B is not able to pay anything. Only C pays 50,000. So decide on what ground how much A can collect it from D. Bacho, here, as per the provision of the Indian Contract Act, remember, when two or more persons have joint promises, two or more persons have joint promises, then unless a contrary intention appears by the contract, there is a contrary intention appear by the contract, all such person must jointly fulfill the promises. But here what happens? There is a contrary appears. As per the section 43 When two or more persons, remember, when two or more persons makes a joint promise, the promise may, in the absence of express agreement to the contrary, the compel any one or more of such joint promisers to perform the whole of the contract. Any one or more than one has to perform whole contract. If any one of two or more joint promisers make a default, any of them make a default, in such case, contribution, the remaining joint promiser must bear the loss arising from default in equal shades. Nodi. Ile idru A, B, C, and D. Right? B become insolvent, nothing is collecting here. And C is 50,000, he got it. So total amount was how much, bacha? 6 lakh. Right? 6 lakh. So in that, 50,000 minus Madri because from the C because he's an insolvent here. Correct? All right. Next is what? Remaining 5,50,000. Remember, remaining 5,50,000 divided between A and. Got it? Artha ki diya? Idhar artha. In the case A, B, C, D have jointly promised for 6 lakh rupees to pay F. So each of them liable for contribution of 1,50,000. And B and C become insolvent. B was unable to pay any amount and C could pay only 50,000. So A is compelled to pay the whole amount to F. Since A paid the whole amount, can recover from 50,000 which he is liable to pay. Right? The loss of B, 1,50,000 shall be borne by A and D. Got it? In their proportion, 75,000 each. The loss of C is 1 lakh. That is 1,50,000 minus shall be borne by A and D in the proportion of 50,000 each. So D is liable to contribute A's his own share of 1,50,000, B's loss 75,000, and C's loss of 50,000. Hence, A is entitled to receive 50,000 from C and 2,75,000 from D. Understood? Understood, bacho? Artha gideya? Any doubts you have? Priyanka, tell me, bacha. Artha gide do? Take a big ahead, amma. No doubt? Doubt ilwa? Tell me if you have any doubts here. Diya? No doubt, bacho? Chalo. Next, X. See, these are the joint promises. Artha ki de do? You want me to explain this once again? Understood or not? Please respond, madam. Chalo. X and Y, because we are dealing with the joint promises now. X, Y, and Z joint borrowed 50,000 from A. Altogether, they bought how much? 50,000 from A. The whole amount was repaid to A by Y. Whole amount is repaid by to A by whom? A Y. Decide in the light of the Indian Contract Act 1872 whether Y can recover the contribution from X and Z. Legal representative of X are liable in case of X death. Yes, it is. Yes, it is. Y can recover the contribution from assets in case of Z. It became a insolvent. Yes, bacho. See, Y can recover the contribution of X and Z. Yes, as per the section, as per the Indian Contract Act 1872, when two or more persons have made promises, when you two or more persons made promises, then unless a contrary intention appears from the contract, all such person jointly fulfill the promise. Jointly fulfill the promise here. Remember, they have to fulfill promise jointly. However, liability of joint promise is joint, right, as well as serve, right? If any one of the joint promiser makes the payment on behalf of other, here X, Y, Z, Y paid on behalf of X mate Z, he can recover the from other their contribution, right? Right, bacho? Now, if any one of the joint promise makes default, in this case X and Z, if any of them make default in such contribution, is unable to pay remaining joint promises, must bear the loss arising from such default in equal share. Means if X and Y, if out of these three, if Z is insolvent, X and Y should share his loss, right? His loss. In the event of death, yes, death of any of them, his or her legal representative jointly with the survivor, and in case of death of all the promises, the representative of all the jointly must be fulfill the promises here, right? But so in above case, what happens? X, Y, Z joint borrowed, right, and Y repaid the entire amount to Z here, the person who from there who borrowed. So yes, Y can recover from X and Y to their contribution. Yeah. Second, in case of death of legal representative, shall pay the X share here. Remember, X share. If X died means his representative shall pay the contribution whatever they're supposed to. However, the liability of legal representative is only up to the assets of X received by him. Understood? Now, in case of Z become insolvent, the amount can be recovered from his asset if asset does not cover the entire amount of a loss shall be borne by X and Y. Understood? See, if Z is insolvent here, all right, and his assets can be used to repay the loss. If the loss is not sufficient, in that case, the remaining person X and Y should bear the loss equally or whatever the proportion. Understood? Understood, bacho? Next question. Ajay, Vijay and Sujay are partners of a software business. Jointly promised to pay 6 lakh to Karthik. Ajay, Vijay and Sujay jointly promised to pay 6 lakh to Karthik. Over a period of time, Vijay become insolvent. Bacho, he become insolvent here. His loss can be bear by Ajay and Vijay according to proportion. But his assets are sufficient to pay the 1/4 of debt. See, total was how much, bacha? 6 lakh. 6 lakh, if you divide by 3 means each person supposed to pay how much? 2 lakh here. Correct? And Vijay become insolvent here. If he's become insolvent, his assets are sufficient to pay 1/3 of debt. So 1/4 of debt. So iska 1/4 is birthday. Is there the 1/4 birthday? 50,000 only. So remaining is how much, bacha? 1,50,000. Right? 1,50,000. So this 1,50,000 supposed to be paid by Ajay and Sujay. Sujay compelled to pay the whole amount. Sujay said, no problem, I will pay the whole amount. Decide whether Sanjay is required to pay the whole amount himself to Karthik in discharging the joint promises under the Indian Contract Act. But so this is very important question, right? Similar question we have. Listen, as per the section 43 of the Indian Contract Act, when 2 or more persons, remember, when 2 or more persons make joint promises, the promisee may, in the absence of express agreement to the contrary, compel any or more of such joint promises to perform the whole of the promises. Right? Hodula. Any one or more of such promisers to perform the whole promise. Yadra obra adarli jimmedar tagondo pay madabodu. One joint promiser may compel the other joint promise, right, to contribute equally with himself to the performance of the promise. out of 3 ದಲ್ಲಿ ಯಾರೊಬ್ರು any one of them can fulfill the whole promise unless the contrary intention appear from the contract. If any one of two joint promise make defaulted, any one of two make joint promise defaulted, in such case the remaining joint promiser must bear the loss arising from such default in equal ratio. In equal ratio. Now the question is that bacho, okay, they are given one more same thing here. X, Y, Z are partners in a firm. They jointly promised to pay 3 lakh rupees to D. Y had become insolvent and his property is sufficient to pay only how much? 1/5. So bacho, 1 lakh is the each contribution. 3 lakh total amount. Out of that 1 lakh, out of this only 1/5 has been received. That means 20,000 only they have received. Correct? So X paid the entire amount to D. Since X had paid the share of Y and Z, he shall have right. He has the right to recover his share of the contribution from them. As Y was insolvent, he would contribute only 1/5 of the total share. He can recover 20,000 from Y. Therefore, in the above case, X can recover 20,000 from Y here. Understood? Understood, bacho? Tell me guys. Tell me fast. Hedappa, those who are watching on the YouTube. ಅರ್ಥ ಆಗಿದೆಯಾ ಕೌಶಿಕ್? No doubt. Now, Sonumal, a wealthy individual, provides a loan of 80,000 to Dattumal on 26/19. The borrowed Mr. Dattumal asked for further loan of 1,50,000. First, he got how much? 80,000, right? And again, Dattumal wants 1,50,000 loan. Okay, Mr. Sanumal agrees, but provide a loan in a part of different dates. He provides 1 lakh. See, this 1,50,000 he has given in a 2 different dates. 1 lakh at one date and the remaining 50,000 on one date. That is 28 Feb and 3/3. That is 50,000. That's the remaining amount he got it. Got it. Now, on 10th March 2019, Mr. Dattulal, while paying of the part of 75,000 to Mr. Sonumal, right? He has 2 loans here, but second loan he made again 2 different dates. Instead, the lender should adjust 50,000 towards the loan taken on what? Loan taken on 3/3/2019. That is, he is telling to adjust 50,000 from here. And balance against the loan taken on, that is 1 lakh. No, balance against this one, 80,000. Got it, bacho? So, total 3 loans are there. He's paying 50,000, right? 50,000. Sorry, he is paying how much? He's paying 75,000. And that 75,000 he want to clear one loan, that is March, and 25,000 he has want to adjust with the loan taken for 80,000. Got it, bacho? Now, Mr. Sonulal object this agreement and asked the borrower to adjust the order of the date of the borrowed funds. He want first whatever the loan you have taken, just adjust that first. Later you can go for the second loan and third loan. See, ultimately here the borrower, who is the borrower, bacho? Dattumal is paying the loan, but Sonulal is asking to adjust the first loan, that is 80,000, and remaining 1 lakh and 50,000. whether the contention of the Mr. Dattulal, the person who has taken the loan, correct or otherwise as per the provision of the Indian Contract Act 1872. One, listen, we'll discuss that one by one. What would be the answer in case of borrowers does not insist on such order adjustment of the repayment? What would be the mode of adjustment or appropriation of such part payment in case neither a Sonulal or Dattulal insist any order adjustment in other part? Such a very important question. This question they have asked in the year to November 19. Very important. But listen, there are 3 loans they are given. One loan is on 26/2, second loan is on 28/2, and third loan is on 3rd March. In span of 2 months, they are given 3 loans here. All right. Now, in the case where debtor owes several debts, means the receivable amount, he has too many different, to same creditor and make a payment which is not sufficient to discharge all the debts. Right? See, when a person has given loan to a same person, but at a different date, this is debtors, for him it's creditors. Right? So what it says is that in case where the debtors owes several debts to the same creditors and make payment, right, makes payment which is not sufficient to discharge all debts. See here, 80,000 and 1,50,000. Total how much, bacha? 2,30,000 is a loan, but he is making how much? Only 75,000, which is not sufficient to discharge whole debt here. Correct? That the payment shall be appropriate, means that should be adjusted against the debt as per the provision of section 59(2)(61) of the Indian Contract Act. Right? Under section 59 of the act, where debtors owing several different loan to one person make a payment to him either with the express intimation or under the situation implying that payment is to be applied to discharge the some particular debt. See, if there are, how many debts we have? 80,000 we have. One debt is 50,000. Another debt is 50,000. The payment should be made to clear at least one debt here. Got it? Got it? Means under section 59 of the act, what it says, where debtors owing several different debts to a one person make a payment to him either with expression, intimation, or under circumstances implying that payment is to be applied to discharge at least one particular debt. The payment, if accepted, must be applied accordingly. If the payment is accepted, must be applied accordingly. This is section 59 says one part. Second, under section 16 of the contract says, where debtor has omitted to intimate, means the person who is repaying the debt is omitted, he missed to intimate, and there is no other. Right? So in above case, Bacho Dattulal had taken a various loan. We know that total 3 loans he has from Sonumal on the various date. So Dattulal pays a part of debt specifying the debt to be set off. He's telling, specifically he's telling, this is the debt he should. So set off. Mr. Sonal object and ask the borrower to adjust the order wise. He wanted to pay first 80,000, next 1,50,000. Since the debtor has specified, right, the order of settlement in creditor has to accept it. Means at the time of payment, debtor has what? He has intimated him. He has told him. He has specified him. Right? Thus, the contention of Mr. Dattulal is correct and he can specify the manner appropriate of repayment of debt. First case. You got it? You got it, bacho? Here what we want is that at the time of taking the loan, see, specification of debt to be set off, if they are mentioned, this is how we are going to prepay the loan. In that case, the Dattulal would have accepted. But Sonulal has, after taking the loan, at the time of repayment, he is specifying that is not going to be settled. Right? So now, the connection of Mr. Dattulal is correct here. And he can specify the manner appropriate to repayment of debt. Next question, bacho. Next question is that what would be the answer in case of borrower does not insist? Means the person who is Dattulal does not insist on such order urges the repayment. Bacho, remember. So, one nimsha. Let me clear this now. In this case, what happens here? There is an intimation given. So, Dattulal is correct here. He can make a first payment settlement. And now, in case of Dattulal fails to specify the manner at the time of repayment maduvaga, at the time of repayment, he is not telling, he is simply paying that. Because, so total how much we have? 3 loans we have, altogether 2,30,000, and he is not specifying which loan should be paid first. So in case where Dattulal fails to specify the manner of appropriation of debt on part payment, Mr. Sonulal creditor can appropriate the payment as per his choice. You got it? Understood, bacho? Very important point we are discussing here. You can expect this question for your December attend, bacho. Understood or not? Priyanka, arth agidiya? Tell me guys, those who are watching on the YouTube, understood this? Please say yes, sir. No doubt? Now, next question is that what would be the mode of adjustment or appropriation of such part payment in case neither Sonulal or Dattulal insist or order of adjustment on there? No one has said. Simply, the Sonulal is paying and Dattulal is receiving here. Bacho, here what I am saying is that in case where neither, listen, remember one thing, Sonulal is what the loan giver, Dattulal is receiver. Correct? First case, yes, this cannot be. Whether the contention of Dattulal is correct or otherwise as per the provision of Indian, yes, it is correct here. Because he just want to say that to settle the first loan. And next, what would be the answer in case a borrower does not insist on such order? So according to Sonulal, it can go. Correct? According to Sonulal, we can settle the debt. But nobody, neither a Sonulal or Dattulal, neither a creditors or debtors, having any kind of adjustment or appropriation of payment, in that case, bacho, what is the solution is that in case where neither Dattulal or Sonulal specify the manner of appropriation, means settlement of the debt on the part payment, the appropriate shall be made in order of time. In order of time means first payment 80,000, second 1 lakh, next settle the 50,000. If there is nothing specifically given about this, right? The appropriation shall be made order of time proportion to debt. Understood? Understood, my dear student? Any doubts you have? Tell me, guys. No doubt? Looks like you don't have any doubts now. Can you go for the next? Those who are watching on the YouTube, please like Madri, share and subscribe, my dear student. Next, Mr. Murari owes a payment of 3 bills. He has 3 bills here. Right? 3 bills. To Giridhar. He has 3 bills to Giridhar here. Now the question is that as on 31st March 20, right, bill 1 is 12,120, which was due on May 16, 5,650, which was due on August 18, 9,680, which was due on May 19. Okay. Murari made the payment on 1st April 2020 as below, without any notice how to be appropriate. He has not said any appropriation, right? He has not said any appropriation. He made the following payment: a check of 9,680 and a check of 15,000. Advised under the provision of Indian Contract Act. Bacho, listen, without any notice. There is no notice here between Murari and Girdhar. What happens? Bacho, if the performance consists of payment of money and there is a several debts paid, the payment shall be appropriate as per the provision of section 59, 60, 61. Remember, of the Indian Contract Act 1872. The debtors, the person who has received, has at a time of payment has a right to appropriate the payment. At a time of payment, he can specify, he can tell these are the money we are paying for so and so loan. But if he not, in default of debtors, the creditor has option to elect. Creditor has option to elect, and in default of either, one second, in default of either, the law will allow appropriate payment in order of date. In order of date. So, bacho, here due date is first what? We can say May, second this one, and third this one. Correct? So, in the present case, Mr. Murari had made two payments of check. One check is exactly amount of the bill drawn. Correct? Yes or no? One check which is exactly amount to bill drawn. Look at that. That is 9680, 9680. And second is that 15,000 we have, we can adjust here. Correct? Now, what is the question is that it would be understand even though not specifically appropriated by Mr. Murari, that it will be against the bill exact amount. Hence, the check of 9,680 will be appropriate against the bill 9,680, which was due on May 19, and check of 15,000 can be appropriate against the lawful debt which is due even though the same time barred. Hence, Mr. Girdhar can appropriate the same against the debt of 12,120, which was due on 16, and balance 5650, which was against due on 18. Means what we can do is that, bacho, this 9,680 can settle against this bill, that is 9,680, and 15,000 can adjust against this first bill, and remaining amount should be adjusted against the bill which is comes after last in the order of payment. Understood? Understood, bacho? Understood? Any doubts? No doubt? Tell me. Bega head report. Priyanka, doubt idenama? Next, Mr. Jyot entered into agreement with such you can say, to purchase his motor car, right? So now tell me, J has entered agreement with the S to purchase S motor car for 5 lakh. All right, within a period of 3 months. See, J is ready to make a payment to S 5 lakh rupees within a period of 3 months. A security amount of 20,000, initial deposit 20,000 was also paid by J to S. In terms of agreement, as per the agreement, they paid 20,000, remaining 4,80,000 supposed to be paid. After completion of 3 months, after completion, because agreement over 3 months, right? After completion of 3 months of entering into agreement, Mr. S tried to contact J to purchase the car in terms of agreement, right? He tried to contact this person to purchase the car, right? Terms of the agreement. Even after lapse of another 3 months, means 3 months is gone. Again, this 3 months is gone. Mr. J neither responded to the Mr. S nor his phone calls. After lapse of another 3 months, that is of 6 months, Mr. J contacted S and denied to purchase the motor car. Means after how much? Approximately 1 year, you can say. After 1 year, he said, I don't want to buy your car. He also demanded back the security amount of 20,000. He said, from S. Referring to the provision of Indian Contract Act, state whether S is required to refund the security amount to J. Also examine the validity of the claim made by J if the motor car would have destroyed by accident within the 3 months agreement period. So, the situation is that performance has been not done by Mr. J. Promise to pay 4,80,000 has not done, and after lapse of agreement, he has turned back and he said, I don't want to buy the car. Now, remember thing, provision of the section 65 of the Indian Contract Act. Remember, bacho, section 65 of the Indian Contract Act. When an agreement is discovered to be void, or when contract become void because of non-performance, any person who has received advantages under such agreement or contract is bound to restore. Right? Right, bacho, they have whatever the advance money they have received, they have to restore. But, or it may compensation for it the person from whom he received. However, if the amount received under the contract is a security, remember, very important, as a security, if they fail to perform the contract, then gone. Right? Security for the performance of the contract, then such security is not benefit derived. And see, security the law or the benefit law. Right? And if party giving the security fails to perform the contract, he will not get back the security amount. Right? However, if the subject matter is destroyed before the contract is performed, the contract become void and party can claim back the security. But here what happens? The subject matter of the contract is not destroyed before the contract. So, in our case, Mr. J contracted to purchase Mr. S his car for 5 lakh. He also gave a security deposit of 20,000 for the contract. The purchase of the car was made in 3 months, supposed to be in 3 months. After lapse of 3 months, Mr. S tried to contact Mr. J, but he did not respond. Later, he refused to purchase the car and asked for the return of the security money. But security money cannot be refunded. A contract is not void contract here. Mr. S is not responsible for J's negligence. So therefore, S can cancel the contract on the ground that impossible to perform within a stipulated time and retain the security amount, since security is not benefit received under the contract. It is a security, is not a benefit received under the contract. It is security that purchaser would fulfill his contract and ancillary to the contract for the sale of motor car. Right? Regarding the second situation, what is second situation, bacho? Second situation is that, bacho, also examine the validity of the claim made by the judge if the motor car would have destroyed by accident within the 3 months. Within 3 months, the motor car destroyed. Bacho, regarding second situation where the motor car is destroyed, right, agreement became void due to destruction of motor car, which is subject matter of agreement. So therefore, security amount received by judge is required to be refunded because within the agreement, motor car got destroyed here. Understood? Understood? A very important question, my dear student. Remember this. This question you can expect for your December exam. Enumerate the person by whom contract may be performed under the provision of Indian Contract Act. See, performance is a very important, right? Performance. Who can perform the contract? Right? Who can perform the contract? Remember, definitely, bacho, as per the section 40 of the Indian Contract Act, promise, the promise under a contract may be performed as the circumstances may be permits by the promiser himself, first thing, right, or by his agent or legal representative. So promise under the contract may be performed by promiser himself or his agent or, my dear student, their representative. Now, promiser himself. Bacho, this question they've asked in MTP, but you can expect bacho, who can perform the contract. Very important point. So, if there is something in the contract to show that it was intention of the parties that the promise should be performed by promiser himself, such promise must be performed by promiser only. He cannot appoint his agent. He cannot ask his representative to perform. Got it? This means that contract which involve exercise of personal skills like acting, dancing, right, painting, that or which is founded by the personal confidence between the parties must be performed by promiser himself. Understood? Understood, bacho? Understood? Next, agent, where a person consideration is not foundation. Personal consideration means that contract can be performed by anybody else. Third person or agent. Yes, bacho, contract. The promiser or his representative may employ a contention of competent person can perform it. Got it? Got it, bacho? Next question is that legal representative. If any person died, the promiser is died. But a contract which involve use of personal skills or founded on the personal consideration comes to an end on the death of the promiser. As regard any other contract, the legal representative means if the contract is which is not a personal skills, which does not require any kind of diligence or a specification to perform a person, in that case, on his death, his or her death, their legal representative can perform the contract. Unless contrary intention appears, look at that, contrary intention appears from the contract. But their liability under the contract is limited to the value of the property they are inherited from the deceased person. Got it? So these are the performance of the contract. Third person. Guys, in the last class we have discussed, even third person also can perform, even joint promises also can perform. So third person, see, section 41 of the Indian Contract Act, when promisee accept, promise means the person who's supposed to get the promises, I mean the person supposed to be waiting for consideration. Promisee accept performance of the promise from third party. Once they accept, remember, say A is supposed to perform for B's consideration, but he fails. C said, I will pay it. When he accept, promise he accept. In that case, he cannot after enforce against the promiser. Once he accept, he cannot enforce to perform A. That is, performance by stranger, accepted by the promisee, produce a result of discharge of the promise. He can be, say, he will be discharged from the contract. Although the latter neither authorized nor ratified the third party. Got it? Got it, bachcho? Very important. Joint promise is very important. When the contract has two or more party promises, right, have made the joint promises, then unless contrary intention appears by the contract, all such person must jointly fulfill the promise. All the promisers, all the joint promise has to fulfill the promise. If any one of them dies, their legal representative must jointly with the surviving promiser fulfill the promise. If all of them dies, means the legal representative, all of them fulfill the promise jointly. Understood? Understood, bacho? Understood? Tell me fast. Please read that. I'll get the water. Please read that, bacho. Guys, no doubt. Can we proceed now? Okay, let's begin now. Singane entered into contact with Mr. Sonu to sing in his hotel for 6 weeks, every Saturday and Sunday. But we have discussed this question the last class, right? We have discussed this. I don't want to waste the time here. Please go and check that previous question. Next question is that, guys, explain the 5 circumstances under which contract needs to be performed with the consent of both the party. Here, bacho, both the party required consent here. December 21 and MTP. Very important. They want 5 situations. Bacho, remember, they want 5 situations under which contract need to be performed with the consent of both the party. Guys, which are the contract situations where both the parties' consent is required? Both the party consent. Look, novation, recession, alteration, and resigned by voidable neglect of promises. Okay? So let's start now. Let's start now. Read that now. These are the 5 situations where contract can be required consent from both the party. See, following the situations where, what is novation? Tell me what exactly the novation is. See, novation means where parties to the contract substitute a new contract against old. It is called novation. Means a contract is there, they just want to cancel the old contract, against that they want to open a new contract. A contract in existence may be substituted by new contract either between the same party or between the different party, right? The consideration mutually being discharged against old contract. The consideration, whatever the consideration is there, right, that has to be mutually discharged between old party. Novation can take place only by what, my dear student? Remember, this is a very important point. Novation can take place only by mutual agreement between the parties to the contract. On the novation, remember, on the novation, old contract is discharged and consequently it need not be performed. Once the old contract is discharged, new contract is to be performed. So old contract is not need to be performed. Section 2 of the Indian Contract Act 1872. Next, recession. What is that? Cancellation. We are cancelling the old contract. So a contract is also discharged by recession. When the parties to the contract agrees to reside, cancel it, the contract needs to be performed, need not to be performed here. Here also, both the party consent is required. Section 62. Alteration. If you are doing any kind of modification in agreement or alteration in agreement, where the parties to the contract agrees to alter it, the original contract is cancelled. Once the agreement is planning to alter, the agreement to contract is cancelled, with the result that it need not be performed. In other words, contract is also discharged by alteration. Once the agreement is altered, bacho, old contract is gone, right? That means it has been discharged from performance. Got it? Now, remission. Every promise may dispense with the or remit, wholly or in part, the performance of the promise made to him, or may extend the time for such performance, or may accept instead of it any satisfaction which he think of fit. In other words, contract is discharged. Remission means, bacho, if you are doing any kind of promises, may be dispensed with the remit, wholly or in part. The performance of the promise, listen. The performance of the promise made to him, or may extend the time for such performance, or may accept an instead of it satisfaction which he thinks is fit, is called nothing but remissions. Understood? Understood, bacho? Next is that reside, voidable contract. When a person at whose option the contract is voidable, reside, cancelled, right? The contract which has taken by undue influence, the other party to that need not perform any promises in that contain the which. So neglect of the promise is also another way. If any promise need or refuse to afford the promiser reasonable facilities for performance of promise, the promise is excused such neglect and refusal to any non-compliance cause, also called as a both the parties' consents are required here. Understood, bacho? So looks like we have done with that. So guys, from tomorrow onwards, we'll start taking the sale of the goods act now. Okay? So we have all that now. I already have shared the PDF with you. Please go through it. And if you need anything, any help, definitely please let us know. From tomorrow onwards, my dear student, I want to start sale of the goods act. Once the sale of the goods act is over, we can start the partnership. All right, bachcho. Chalo. So like, share and subscribe, and definitely from tomorrow onwards we will begin with your sale of the goods act, and we'll try to finish the chapter. And most probably evening also we have a accountancy class, bachcho. Join Agripa. Chalo guys, bye bye. I'll catch you in the next class.